everyone. This week we are looking at precedent, and like last week when we looked at legislation and rules-based systems, this is material that you've covered before, but we're looking at it again in more detail, and hopefully with a little bit more time for reflection and a bit of time to understand more how it all fits together. Because when you do all this in intro in first year, you're very much inundated with everything at once. So it's a good time in second year to come back and to have a think about it again, and also to think about some of the unusual features of precedent, because it's something that is quite different to anything that you will encounter outside the law. Last week we looked at law as rules, largely through legislation, although precedent also does include statement of rules. And this is more familiar with most people, where you have a list of rules: do this, do this, do this, or usually it's don't do this. It's hard to set rules that positively create behaviour. It's much easier to create negative rules. So, but we're familiar with the idea of rules. But the idea of precedents in the idea of the common law system is something that is quite unusual, and it's certainly something that's often confounding non-common law legal scholars who go their whole lives just dealing with rule systems, and then hit the common law system, and it's like, well, why are these precedents so important? So we looked at, in one of the other videos, the idea of the bedtime rule, to give you an idea of how there's an interplay between rules and precedent in the common law system, and how it's one of the unique features of our legal system, and that ability to moderate a harsh rule or a set rule by all that the different forms of application that are used, and the negotiation that goes on through the reporting of precedent. Now, this is something which makes the common law system very flexible and very able to change and evolve with time. But it's also something that is very frustrating for many people, because it does make the law more uncertain. Even a law that's an unfair law, if it's just written as a rule, ahead of time that going into it, this is the way it's going to be applied. But with precedent, it's always arguable, and there's always a great number of precedents out there that can apply. Then there's, the narrow field of those that apply directly, that are the direct authorities, and then there's a huge, vast sea of obiter dicta, increasingly remote levels of application. But you can always find something up your sleeve and say, but, in this case, there's a very strong precedent, different area of law, but if you apply it by analogy to this area, you'll find that it, has a different sort of outcome. And this is the area in which advocacy certainly has that ability to have the individual, unique insights and ability of the advocate come to the fore. And unlike the movies, where it's just about, being able to make a passionate speech, which law is almost never about, the real skill of advocacy is that ability to think laterally around precedents and to be able to say, okay, the law seems to be applying in this way on the face of it, but I'm going to come up with a very interesting and cohesive and convincing argument. And all the big cases do that. I mean, Donahue and Stevenson, years and years and years of precedents that say there's no such thing as negligence. And they found a way of arguing for a change that the court wanted to make anyway, and said, let's recognise this new area of law, let's recognise precedent, and let's do it in a way that at least appears to be consistent with all the body of authority beforehand. All right, so this is one area that many students graduate from law school without very good skills in the use of precedent. Partially it's because of the way traditional legal education promotes rote learning of lots and lots of cases and principles, and we often don't have time to sit down with individual cases and authorities and work through them in detail. And that is the sort of thing you have to do in practice. That is, if your practice is, appeal court advocate, which is not very many people. And I know it's kind of strange that we spend a lot of your undergraduate degree preparing you for a job that not many graduates do, but that's a totally different topic. But if you are an advocate at that level, what your experience is in reading and understanding those cases. And if you're a judge as well, Michael Kirby famously had his pile of law reports by the bedside table to read every night before sleeping. which is, not necessarily for all of us. But if you want to perform at that level, you need that understanding of the law. And again, to get back to the point I was making, a lot of the criticism of graduates is that they can't read a case, they can't apply a case. So we're going to help you through some of those skills. Like every other skill, it only improves through experience. Listening to a video is not going to help you, and it may give you some pointers, but the only way you get it better with this is through engaging with the material and working with it. And from my experience, moots were the best experience for this, because moots force you to actually tackle serious, important cases where there's arguments on both sides, and they force you to actually read the original cases. And that's what you need to be able to do to get better using cases, is to read them. It's the same with legislation. You get better at understanding and applying legislation by reading the legislation. It's one of those areas there are no shortcuts. It's like becoming Jackie Chan. You don't get to be Jackie Chan by watching some videos and making shortcuts. You do it by having a grueling apprenticeship with the Beijing Opera and learning your martial arts and learning your acrobatics and everything else. A lot of things, it'd be nice if I could say, here's the magic way to be a brilliant advocate without actually trying, like Harry Potter does it. But, the real world, you get better by practicing and practicing and practicing. All right, so with that sad news, this week's readings are again revision of material you covered in first year, but it is probably time to cover that again. And I'm quite surprised sometimes when I, talk to latter year students who don't know their ratio decidendi from their obiter dicta, who aren't clear about the way you distinguish cases and all those sort of key important skills. That's what we're going to talk about this week, is those sorts of skills. And also in the use of majority and minority judgments and how those are used. Because quite often it's very tempting for people to go, oh, minority judgment, well, just not bother with that. It's obviously irrelevant. And there are lots of situations in which minority judgment's extremely important. So lawyering is about metaphor, it's about interpretation, it's all about language. And again, you occasionally at open days have students say, I want to study law, but I don't like reading. In which case it's like, just do something else. Do something else. This is a reading-based discipline, and everything that goes with it. I mean, one of the hardest things about reading is, of course, making the time for reading and making purposive time for reading. So it's not just a case of, I'll pick up some of that a little bit on the train or a little bit before bed. Being able to set aside other priorities and say, no, this afternoon I'm going to be reading those cases and I'm going to focus on them, and it doesn't matter what else is important. Because reading doesn't necessarily give you the best feedback in terms of, risk reward. You can spend a lot of time reading and then go, well, I don't feel like I've gotten anywhere. And that's again part of the skill of becoming a better lawyer, is to be able to manage your time and to be able to manage your own self, in that you can do those long bouts of reading without feeling as though you need that constant, feedback of, this is good, this is good, this is good. Because there's a lot of dredging, a lot of reading and skimming, and a lot of active reading involved. All right. The way to get better at law is to get better at language. It involves reading, it involves writing, and it involves appreciation of a wide variety of different forms of language in the law and outside the law as well. All right, so the workshop this week is focusing on looking at a single case and developing an analysis of a single case. And that goes well beyond your IRACs. We had a little look earlier in this term at some of the uses and misuses of IRAC, but all IRAC does is give you a really, really basic summary of a principle in a case. And that doesn't give you a working knowledge of the case. We're going to look at a little bit more detail about actually digging into a case and finding out, what the good stuff is. It also involves moving beyond the facts and what was decided in terms of the facts of a case. In pretty much most precedents you're going to hit, the facts are almost irrelevant. The things that are good about facts is they help you remember cases. So Donahue and Stevenson, snail in the ginger beer bottle. It doesn't matter that it was a snail. It doesn't matter that it was ginger beer. It could have been a Taipan in a Fanta. for all the principles of the case require. But it's those facts give you those memory prompts. But sometimes students get very much focused on, well, what was decided in the case? What was the facts? What was the outcome? And usually when we're looking at a precedent, what we're interested in is the principle of law involved, not so much the way the case was decided. Part of what we're also doing here is trying to understand the policy framework that surrounds the case and what real or implied, visible or implied limits there are on a judgment. There's often a situation where judges will want to decide a case in a particular way, but are limited by, the surrounding precedents and the available options that are available to them. And there are, principles they use like the floodgates principle, which is we would like to decide this case in a particular way, but it will open the floodgates to massive amounts of litigation. So we'll make a conservative decision because at the end of the day, the courts are not going to be able to cope if we open up this area of law for everyone to sue. Now, that's a policy decision the courts are making that is not necessarily going to be obvious on the facts, but it's possibly going to be something that you will notice if you think about the case and you think about, okay, they didn't allow that principle through. What would have happened if they did let that through? Oh, okay, everyone's going to be suing everyone else. I can see why they didn't do that. So the policy around a certain case is not, there isn't a policy section where they write down what the policy is. And in a moment, we'll come to some of the reasons why that is, another reason why they don't do that. But it's about understanding that context, and it's and that's something you build up over time, as you understand the law and you understand a little bit of legal history. The other thing you need to be on the lookout is for the take-home message that's in a judgment, the area where the judges are using the case as an opportunity to set standards for later on, and this happens in obit dicta traditionally, where they say, and this can be, again, they can say it expressly or it can be implied, where they can say, here's a message to all future litigants. In future, do this or don't do this, or here's an area that we think if the right case came along, we would like to see the law develop. So as you become more experienced in reading cases, you start to be able to read that and start to detect these sort of current changes and these weather changes in the law, and where judges have indicated a willingness to change. Now, you don't get through that through IRAC, and you definitely don't get that through reading head notes or nutshells. And those are the deeper layers of understanding and research that skilled advocates have, and that things that move you much further in your career than taking shortcuts. And a lot of what you will then be doing when you're looking at cases is looking for uncertainty. And that's a little bit counterintuitive, because usually you're looking for certainty. You're looking for, well, what does this case say? What is the outcome of this case? You're actually not looking for that. What you're looking for is, where are the areas where the case may not be absolutely certain? Where are the situations where the case could be distinguished? Where are the situations where the case involves principles that may be applied differently in different circumstances, and we don't really know what the answer is? I mean, that is the area in which litigation operates, in those areas of uncertainty, because it provides an ability to map out the common law in a new area. And particularly for courts where you have to apply for leave to appeal, such as the High Court, you don't have an appeal as a matter of right. They will usually only grant an appeal where there is one of those important zones of uncertainty, where they want to be able to lay down principles going forward for other litigants. So this week we're going to look at some of the skills in terms of mapping out cases, being able to look at how the different judgments interact with each other, how majority and minority interact with each other, and basic skills like noting up, your ability to actually then be able to look at what cases have considered that case subsequently. That's very, very important, because your textbook is going to be out of date. As soon as your textbook's published, it's going to be out of date. So you need to be able to see, is this area of law evolved and changed in the meantime? Particularly important, in court, where you don't want to be embarrassed by the judge saying, but we made a decision on this 6 months ago, don't you read your cases? You need to be able to make sure that you're absolutely up to date, and that's the process of noting up. or shepherdization, if you want to use the American term, which we usually don't. So the focus this week is on how to actually, read and use cases in that practical context. It's very, very much closely related to that advocate court work path, career path. But even others are going to need to be able to do that. If you're just giving advice to a client on an area where they're thinking about getting involved in litigation, you need to get a fairly good grasp of what the area of law is about before you start using the client's money getting a barrister's advice. They're not going to be very happy if there's something you really should have known about to give them advice on, and you send them off to a barrister for very expensive advice, and at the end of the day find out that you really should have known that in the first place. So in other areas of law, it is also relevant, and in law reform and in the public sector, when you're codifying the law, you need to understand what the law is and its cliffs and valleys and the maps of the contours of the law before you seek to codify that and change that with legislation. So what does this reading process involve? One of the problems for first year students and for the rest of us is that cases are not designed to be read by novices. They're designed to be a record of the decision-making process of a judge. So unlike something like a textbook, which you would expect would say, okay, let's start with the baby steps and lead you through the process, a case will presume you have mastery over that area before you go in it. And that can be a big hurdle. And part of that can be to do with the language that's used as well. Older cases use more archaic language. Even contemporary cases use quite formal language. They don't, they don't write like they're writing a blog or whatever else, or even a newspaper article. So part of the skills of reading is being able to plough through that and to be able to sift out the relevant aspects for yourself. And and you might say, well, the textbooks aren't that readable either, and that's a completely different topic, and that's a matter of, writing skill and style. But a textbook is designed to take a novice and work them through the stages to understand a topic. A case is not. And one of the things I know I always found difficult as a student with cases is that cases mix and match areas of law. So you do a case in contract, and it might involve corporations law. It could involve constitutional law, who knows? And there are all these other areas, and they're things that often you hadn't studied yet. And you'd have to be able to work through that material when you're reading a case and to go, look, okay, I'm not sure what this equity stuff is yet, and I don't think it's relevant to me, but I'll just take a note of the general contours of this, and I'll skim through to find the bits about, promissory estoppel, and let's focus on that until I come back to learn equity and actually realise that these things are all interconnected. But that's another aspect of the case report being a practical workplace document, is that there are different areas of law that all intersect and collide in those judgments, and there may be areas that you haven't yet studied. One thing that makes everything much more complicated than it needs to be is a thing called the declarative theory of law. Something we don't teach much anymore, and I'll try to give you the quick version of it, because it was the fashion, the orthodoxy when I studied law, and it has created a whole lot of trouble for everyone, not the least of which being that through the middle of the 20th century, judges operated under the declarative theory of law, and it shaped the way their judgments were written. And sometimes they say things that seem weird or odd to our contemporary perspective, because they're working around this odd principle. So what is it? The declarative theory of law is the idea that judges don't make law, they only find it. And it came out of a period of great uncertainty around the role of the judge in the Westminster system, and there's sort of anxiety around the fact that, well, we've got an elected democratic system, we've got these non-elective judges, and they're making law. Isn't it the role of Parliament to make law? Why are judges making law? And that's very much a gross simplification of what judges do when they make law. They certainly don't do what Parliament does and go out and just create new law out of nothing. if Parliament does that. I'm not sure if they do that either. And judges definitely operate within very set parameters and very much within a continuity of the common law. They're not just going out on whim and saying, like, oh, today I don't like that group of people, I'm going to make a law that's going to make all of what they do illegal. It's not what judges do when they make law. When they make law, they're building on the principles and making decisions about how they apply in the future. Now, that's the day that the way that academic field and judges and everyone else today think about judge-made law. We talk about judicial discretion and the fact that judges do make choices along the way. However, for this sort of ugly period where the declarative theory of law was in force, judges had to pretend that they didn't make decisions. That all they did was go out and find the law. They lift up a rock and it's like, oh, well, Donahue and Stevenson, there's a snail under that rock. And it comes out of nowhere. And this used to create all kinds of angst for first year students, because students were told, take all these inconsistent cases and you have to rationalise them all because they all fit together and they all work. They're all consistent because law is never made, it's just found. And that was absolute nonsense, because you can't do that because law changes over time. Donahue and Stevenson, classic example, but when I learnt it, I was told that Donahue and Stevenson was actually consistent with all those previous cases that they said there's no such thing as negligence. I couldn't figure out how it was consistent at all. It seemed to be a change in decision making. And the truth is it was. But there was this mythology around the declarative theory of law that was in law schools. And importantly for you folks today, it's affecting what judges say. So quite often judges from that period, sort of the mid 20th century, early 20th century to the late 20th century, hedge around making a decision. And they say, rather than saying, I've got two alternatives here, and on the merits, alternative B is much better for these reasons. That's what a modern judge would do. Under the declarative theory, they would say, well, there's only one option. There's only B. And A just isn't an option at all. It doesn't apply. And you sit there and you read those kind of judgments and you scratch your head and you think, really? I thought A looked like a pretty legitimate go. Why isn't that? So that's the explanation for that. It's one of those things that it's thankfully dead and gone, but it's staying around to haunt us, and it's staying around to haunt you as students, where it affects the style that's used by judges. And as I said, it gets back to this sort of period where, there was a great deal of anxiety around the role of judges and what they were doing. And we even see that in the backlash against the Mabo decision, where we had people, including the Attorney General, whose job it was to defend the High Court, let's put that aside for the moment, saying this is outrageous, the judges are just making law, whatever. And the Mabo decision is based on solid international law principles. The judges are not doing anything in terms of lawmaking that's outside their field at all. But when politicians don't like the outcome, of course, they turn back and go, these are not elected people, how come they're taking away things from the role of Parliament? Becomes particularly sticky with constitutional law, I must say, because that's an area where once the court makes a decision, it pretty much sticks. And those are areas where Parliament can't then go away and just pass another law and change, and get around the judicial interpretation. When it's the Constitution, it becomes fixed. So that's an area where they get very, very narky if they don't like the outcome of what the judges have said. But as I said, there's never been, particularly at the High Court level, a judge who just goes off on a little whim and says, well, I'm just going to make something up today. I don't like the look of the person here. I'm just going to make up a new law, and we're going to make a decision just based on our own preferences. Now, sometimes they sort of do that in private. They come to an intuitive understanding or a personal understanding of how they want the decision to come out, but they still have to go back to the legal principles and argue it through principles. So, judicial lawmaking is like any expertise field. It's like doctors. Doctors don't just decide to, put Vegemite on a wound because they want to see what happens. Well, no, real doctors don't. Dr. House probably would, because he's always coming up with wacky solutions. But real doctors operate within the field of medicine and science and understanding. You make a good decision, you can make a bad decision, but you do within that context. Same as what judges do. All right, so that's a long way around the declarative theory of law. Had a time machine, that'd be one thing you'd go back and change, because it's something we're still living with today. So what does that mean in terms of legal research skills? Well, it means you've got to be good at reading between the lines, and that's declarative theory or no declarative theory. You've got to be able to understand that judges can often say a lot with a little. I'm going to say a little with a lot. And the only way you get to understand that discourse is to immerse yourself in it. It's, if you wanted to be able to understand Shakespeare's plays, you read Shakespeare's plays. If you wanted to understand the way in which, Call of Duty AI works, you play lots of Call of Duty and you learn about programming. Whatever genre you're working in, you immerse yourself in the genre and you learn its rules and you learn the way it operates. Same thing with law. So that's a long way around, coming back to the, lecturer's always nagging you. You've got to read your cases, you've got to do your reading and everything else. But the point is, what you're doing here at law school is not just an outcome for getting a piece of paper. What you're doing is learning lifelong skills. And yeah, there are plenty of shortcuts you can get to get the piece of paper. And I'm sure you know a lot of them. There are lots of ways of being able to skim through without doing all the things you're told to do, to get through your law degree as quickly as possible with as minimum work as possible. But in terms of lifelong skills, use this environment as an opportunity to develop those skills in a non-volatile, non-risky environment. Don't let your inability to read a case, don't let that get found out in a situation where you can lose your job for it. Develop the skills now so that doesn't happen in the future. So that's what we're going to focus on this week. We're going to come back and we're going to look at those core skills. We're going to revise where they were. We're going to look at an actual case, and we're going to have a look at how we can map that out and understand that in a way that is useful for the research process.